Noncompliance with the e-Sign Act can lead to violations and even reimbursement in some cases. One of the many challenges with e-Sign requirements is to ensure that you have reasonably demonstrated the consumer can access the electronic information. The regulation is very specific and states that the institution should obtain consumer consent in a manner that reasonably demonstrates that the consumer can access information in the electronic form that will be used to provide that information that is the subject of the consent. The purpose of the requirement was to ensure that the novice computer users were able to access their disclosures in electronic documents. Spam filters, pop-up blockers, or changes in browser configurations could prevent electronic records from being received or opened. Demonstrative consent means that the consumer has shown the ability to receive and read the documents in the format that your institution plans to use. There are many ways to accomplish this depending on the format, but the consumer should always provide your institution with some evidence that they can obtain the electronic document. Information can be delivered to a consumer via various methods, such as a secure website, in the body of an email, or in an attachment to an email. What must be demonstrated is the consumer's ability to access the exact delivery method the institution will use. There are many ways to demonstrate this consent. One way is to do a test drive to verify the consumer's ability. To do so, you would need to create a test disclosure or document and require the consumer to pick up and return a PIN or a code to you. That will confirm that the consumer can in fact navigate your system and has the capacity to retrieve and respond to electronic records and/or disclosures. So if you want to send e-statements in a PDF file, you would have the consumer open a test PDF and return some PIN or code to you. If you plan to send an appraisal, for example, via email with a link to an HTML web page, you can send sample email with a link to click on to confirm access. This sort of test process will eliminate any doubt about whether a consumer can access electronic information. After the consumer provides the information which proves they demonstrated the ability to access the information, then the consumer would be allowed to complete the consent process. Many institutions retain both the copy of the consent, which is a requirement, as well as the email string verifying the consent and the ability of the consumer. Let's take a look at some examples. This would be considered non-compliant. You're providing the disclosures before the consumer consents and demonstrates that they can access the electronic document. The regulation does not permit the disclosure to be provided until the consumer consents and demonstrates that consent. The next example is considered compliant. The consumer must click on the link that brings them to the e-statement document, and you'll notice disclosures are not provided in this same process. The consumer cannot bypass this link, so the system will not allow the consumer to consent without opening the document. This type of e-sign delivery is also considered non-compliant. Not only is the e-statement disclosure being provided with the account disclosures prior to consenting and reasonably demonstrating that they can access the information, the link to the e-sign statement is broken. So therefore, the consumer is not provided with the required disclosures before they can consent. Because e-sign was not completed properly, from a regulatory perspective, the consumer did not receive the disclosures. This can cause a multitude of issues. Let's say, for example, this was for a checking account, and the fee schedule was not technically provided. The institution may have to reimburse the consumer with fees that were not technically disclosed to them before opening the account. Or on the other hand, if this was for a loan estimate under the TRID regulations, the document would not be considered technically delivered to the consumer, and the lender may have to be responsible for the fees associated with that loan. So let's talk about how e-sign is applied to non-consumers. For the non-consumer, such as an LLC, where Reg B requires the appraisal to be delivered in writing, you can deliver this by mail or electronically. Because the LLC is not a consumer, they are not subject to e-sign requirements. In fact, the Act is silent for non-consumers. If you choose to provide the appraisal electronically for a non-consumer, you must obtain the person's agreement, which does not have to be in any particular form. As this is an agreement, as with any contract, you may want to have your legal counsel review the agreement. Now that we've discussed the key components of the regulation, let's discuss some of the challenges we face in offering various products and services to consumers electronically. Several institutions encourage consumers to sign up for electronic banking at the time of account opening when they are in the branch office. While the regulation permits the e-sign statement to be provided in paper form, the consumer still has to reasonably demonstrate they can access the electronic record. This cannot be completed if they're in your branch lobby or using the institution's computer access. However, if they have their smartphone or tablet or laptop with them, then they could complete the process and reasonably demonstrate that they are able to access and view the electronic record. Your customer has signed up for e-statements, so does that mean you can send all other notices and disclosures associated with the account electronically? It depends upon your consent language provided to the consumer when they signed up for e-statements. If the language in that consent disclosure statement indicated it was just for statements, then the answer is no. NSF notices and maturity notices, for example, would have to be delivered by mail as the consumer did not consent to receiving those additional disclosures and notices. Earlier, when we reviewed some examples of compliant and non-compliant consent, we discussed the timing requirements for the loan estimate under TRID. From the time the lender receives the required information, or what we commonly refer to as the 6 pieces of information, they must provide certain disclosures within 3 business days. If e-signed demonstrative consent is not received, lenders need to have a workaround in place. This includes establishing a monitoring program to determine the consumer did demonstrate consent timely. If not, paper disclosures need to be provided, and since the clock started ticking when you received the required information, monitoring of this time frame is very important to ensure you meet the disclosure time frame. Some of the non-compliant areas of the Act include hardware and software descriptions on the e-statement is outdated, or hardware and software is updated and a notice is provided to the consumer, however the consumer doesn't reconsent under the e-sign requirements. Some best practice options to avoid these issues would include a review of the disclosure statement on at least an annual basis to confirm the current descriptions for hardware and software requirements are current. Also, when hardware and software requirements are changing, as part of your change management control process, compliance should be involved in reviewing the change notice to consumers. The determination if the change is considered material and requires a new consent should be documented. Lastly, policy and procedures should be detailed to include the steps that need to be taken when a change to software and hardware occurs. Disclosures provided before consent is obtained, the consent is for e-sign and includes the disclosures, or being unable to provide a copy of the consent. Some best practices to avoid these situations include testing the consent portion of each platform to be sure the e-statement is provided before consent is obtained. The consumer reasonably demonstrated the ability to receive the electronic document all before the actual disclosures are provided. If necessary, you may want to work with your vendor to document this process. In addition, you want to be able to test all platforms where the record of consent is housed to ensure you can provide a copy of the consent upon request. Having the corresponding e-statement in addition to the actual consent is vital to evidence exactly what transactions the consumer consented to and show that your e-statement includes all of the required language. Non-compliance with e-sign can lead to violations within the various consumer regulations and even have UDAP components. E-sign Act violations are not what is going to determine if there is potential consumer harm. It is the actual regs that you see listed on the slide that are going to dictate what your consumer harm may or may not be if disclosures will not deliver timely. Each of these regulations have serious repercussions for noncompliance with the delivery of required disclosures. Remember, if you can't prove it, it didn't happen. To assist you in avoiding noncompliance, a strong e-sign program should include policy and very detailed procedures. Not only should they include the various requirements, they should also detail the process that should occur. This is going to vary by business unit. If we think of all the various platforms where e-sign is used, it could be in deposit operations or loan operations. It could be on the retail side with opening a deposit account online, or it could be in the various lending departments. Determine within your organization the individual or group that should own the policy or procedures and ensure periodic reviews occur to determine if changes are needed. In addition, monitoring and audit of your e-sign program should include on a risk basis. This process should include testing of each platform used for e-sign at the account opening level, as well as the maintenance of the e-sign consumer. Training is an area that's often missed with this regulation. Your training program should include training to all staff that have communications with consumers regarding the institution's procedures to comply with e-sign. Training should always include a review of your own policy and detailed procedures. This regulation is not new. It was enacted in 2000, and the act consists of all of 3 pages, and much hasn't changed since then. It's really interesting how the e-sign act, that's only 3 pages, can cover so many areas and have so many repercussions if we don't follow those step-by-step processes. Hopefully we gave you a lot to think about today, and if you have any questions, please feel free to reach out and we'd be happy to answer those questions for you.